Good evening. Welcome to Current Affairs. Today, I am going to discuss with you with respect to the procedure for the removal of a judge of High Court. The Constitution has mentioned very clearly why a judge can be removed. What should be the grounds? Grounds means the reasons. So the Constitution has given two reasons. One is the proved misbehavior, and the second one is the incapacity. In fact, under Article number 124, Clause 4, which is related to the Supreme Court, the Constitution has given the procedure for removing a judge of the High Court. Removing the judge of the Supreme Court. And the same procedure what we follow to remove a judge of Supreme Court under Article 124, Clause 4, the same procedure is also applicable for removing a judge of the High Court. Same procedure is also used for removing CAG or Chief Election Commissioner. Meaning, so these are all the constitutional positions, they are removed in the same manner and procedures. But the Constitution has explained and given in a detailed manner under Article number 124, Clause 4, which is related to the Supreme Court. Right? So, but when you reach the High Court article, that is 217, that referred to Article number 124, Clause 4, meaning High Court judges are removed in the same manner and procedure like that of a judge of the Supreme Court. So I would like to explain certain things to you, but why I am talking to you with respect to this one? Because very recently, 55 members in the Rajya Sabha members, so they have given a notice to the chairman of the Rajya Sabha. And the request is that to accept the petition where they want to discuss about the removal procedure of a judge of Hyderabad High Court. So the name of the judge is Justice Nagarjuna Reddy. And the main allegation against him is that he physically assaulted one of the junior judges. So in one of the cases. So on the same issue last year also, in the year 2016, in Rajya Sabha, some of the members of Rajya Sabha, they submitted the notice, but later some people have taken it back. That is the reason why, so there was no progress. So, and this is a fresh step, fresh initiative taken by the Rajya Sabha. But now I would like to tell you how exactly the judges will be removed, why the judges will be removed. Since Justice Nagarjuna Reddy is there in the news, I would like to discuss the removal procedure of the judges of the High Court. So, but before that, I would like to show you the related articles, right? And after that, we'll go ahead and we'll have a detailed discussion with respect to removal of the judges. Look at this. Removal procedure of a judge of High Court. So we are discussing about Justice Nagarjuna Reddy of High Court of Judicature at Hyderabad. And the allegation is that he physically assaulted a junior Dalit judge by name S. Ramakrishna. That is number one. Number two, other allegation against him is that in the year 1997, the Supreme Court has issued the order that all the judges must disclose their assets. It seems that majority of the judges have disclosed the assets, but Justice Nagarjuna Reddy has not disclosed. So this is another allegation. Of course, these allegations must be proved. It will take some time. So that is the reason why Justice Nagarjuna Reddy is there in the news, and against him, the notice has been moved. So regarding that, let's discuss. But before that, once again, I would like to show you the document where I want you to have the exposure towards the related articles. Look at this. One motion was moved in the year 2016, but at the time, few members taken aback. What is the meaning of this? I am going to tell you after some time. But before that, please have a look at this. Article 217, Clause 1, Subclause B. Under this, a judge may be removed. Kindly see here, Article 217 is falling under Part 6 of the Indian Constitution, and this article is mentioning about the high courts. Clear? So, a judge, in the sense, in this particular article, a judge means a judge of high court. So, a judge may be removed from his office by the president in the manner provided in the clause 4 of Article 124 for the removal of a judge of the Supreme Court. What do you understand by this? So, by looking at this article, we can understand few points. Number one, a judge can be removed by the president. Number one, and the manner has been provided under Article 124, Clause 4. That in fact it talks about the removal of a Supreme Court judge. Meaning, by reading this article, we can understand that a judge of a high court is removed in this by the President of India, but after following a procedure as mentioned under Article 124, Clause 4, which mentions about removal procedure of the judges of Supreme Court. Am I clear? So now we know that removal procedure of a judges of High Court is mentioned under article number 217, clause 1, clause B, subclause B. Right? I repeat, 217, clause 1, subclause B. So now this article is referring to article 124, clause 4. So what exactly it is saying? Have a look at this. Just read carefully. Please be patient while reading. A judge of the Supreme Court shall not be removed. Look at this. I'm reading out article number 124, clause 4, which mentions about the removal procedure of a judge of the Supreme Court. This article is saying a judge of the Supreme Court shall not be removed. He cannot be removed from his office except by an order of the president. Except by an order of the president passed after an address by each house of the parliament, supported by a majority of the total membership of that house, and by a majority of not less than 2/3 of the members of that house present and voting, and has been presented to the President of India in the same session for such removal on the grounds of proved misbehavior or incapacity. Right? So this article is making it very, very clear that a judge of Supreme Court is removed by the president after following a procedure. Now I am going to tell you what is the procedure now. But what are the reasons? Why are you trying to remove a judge of the Supreme Court? The reasons are two. Either it is proved misbehavior or incapacity. Okay. So kindly go to the last two lines on the screen. 124, clause 5. It is mentioning Parliament may by law regulate the procedure for the presentation of an address and for the investigation and proof of misbehavior or incapacity of a judge under clause 4. Meaning is simple. If you look at this article number 125, clause 5, it is mentioning very, very clearly that there is a procedure. There should be a procedure for removal. But the procedure for removal should be designed by the so-called the parliament. How the parliament will do it? Introduce a bill, pass a bill, make an act. And in that act, you mention very clearly what should be the process, right? So to investigate the concerned judge. So you need to prove that, so there is a, you need to have the proof that, so he should be charged under proved misbehavior or incapacity. For that reason, there should be a procedure. And that procedure can be designed by the parliament by passing an act. So accordingly, in the year 1968, the parliament has passed Judges Inquiry Act. So it happened in the year 1968, and that particular act mentions what exactly is the procedures. What exactly is the procedure to be followed before the president declares that the concerned judge is removed. So regarding that, so we are going to have a discussion now. Before that, once again, I would like to show you the document. Kindly have a look at this. Look at this. whatever we are going to discuss that is present here. Judges Inquiry Act of 1968. This is an act to regulate the procedure for investigation and proof misbehavior or incapacity of a judge of the Supreme Court or of a High Court, and for the presentation of an address by the Parliament to the President and the manner connected therewith. What do you mean by this? So now let me explain you. So whatever is mentioned under article number 124 class 5 or article 217 class 1 subclass B, for everything you should go and refer to Judges Inquiry Act of 1968, and that particular act has mentioned the procedure for investigation. Just like that, you cannot remove a common employee also. But when it comes to the judges at the highest level, Supreme Court and High Court, so you need to follow a specific procedure, and that procedure was designed by the Parliament in the year 1968. That is the reason why, if you have any problem with any judge like this, like Justice Nagarjuna Reddy, you need to initiate a procedure. You need to initiate a procedure in the form of motion, and the procedure can be initiated either in the Lok Sabha or in the Rajya Sabha. Please listen carefully. The procedure can be initiated either in the Lok Sabha or in the Rajya Sabha. Imagine if it is initiated in the Lok Sabha. The law says that, law means Justice Inquiry Act says it very clearly, not less than 100 members of the Lok Sabha must submit a notice to the Speaker. Lok Sabha is headed by the Speaker, as we know. So, not less than 100 members are submitting the notice to the Speaker, requesting the Speaker to take up this matter and conduct the investigation into this process. Because these are the charges that we are presenting in front of you. If it is initiated in the Rajya Sabha, minimum 50 members of the Rajya Sabha must sign and submit the notice to the chairman of the Rajya Sabha, requesting the chairman of the Rajya Sabha to initiate. Right? Some meaning is simple. If you want to initiate in the Lok Sabha, minimum 100 members of the Lok Sabha must sign and give the notice to the Speaker. If it is in Rajya Sabha, minimum 50 members of the Rajya Sabha must submit the notice to the Rajya Sabha chairman, requesting for initiating the procedures. Right? That's a point number one. Sometimes what may happen, on the same day, this procedure may be initiated in both the houses. Members of the Lok Sabha, members of the Rajya Sabha, then they submit the notice to the concerned chair. So to the Speaker and to the chairman. During that time, what will happen? Because the day is the same, the decision can be combinedly taken by Speaker of the Lok Sabha and chairman of the Rajya Sabha. Right? Meaning the act is saying very clearly, if both introduce this motion on the same day in two houses, then collective decision has to be taken by Speaker and the chairman. If the motion is introduced in two houses on two different dates, the latest house that submitted the motion, that motion will be rejected. Meaning, whoever submits the motion first, that will be initiated. Am I clear? If Lok Sabha initiates first, Rajya Sabha initiates second, the second one will be rejected and the procedure will happen in the so-called this Lok Sabha. Now imagine a situation. So they have initiated a procedures. Say for example, in this particular case, in the case of Justice Nagarjuna Reddy, the procedure has been initiated in the Rajya Sabha. Say for example, now initiated in the sense notice has been submitted. Meaning it is a request made by the members of Rajya Sabha. How many members must sign? 50. But it was signed yesterday by 55 members. And the notice was issued to the chairman of Rajya Sabha. If the chairman considers this, then the chairman will constitute a three-member committee. The chairman will constitute a three-member committee. And the act provides very clearly who are these three members in the committee. Clear? So only from this category you have to pick up the people and they should be made the members. Three-member committee. Number one, The first member should be either Chief Justice of India or any judge of the Supreme Court. Number one, either it should be Chief Justice of India or any other judge of Supreme Court. Clear? So, what is the meaning of this? Why any other judge when CJI is present? Meaning, sometimes the allegation may be against the CJI. That is the reason why this provision has been provided. Number one. Number two, second person should be the Chief Justice of any of High Court. The Chief Justice of any High Court in India, we know that there are 24 High Courts, and each High Court is headed by a Chief Justice. And any Chief Judge of any High Court will be the person who is a member in this three-member committee, right? And third person is a distinguished jurist in the opinion of the chairman of the Rajya Sabha. Distinguished jurist in the sense he is a person with lots of legal knowledge and experience behind him. Generally, the senior most advocates of the Supreme Court are considered to be the distinguished jurist, and one person will be picked up and he will be appointed as a member. Now the three-member committee has been formed. Now the three-member committee will look into the allegations that are framed by, these members of the parliament. And they will, committee has been constituted and they will start conducting the investigation. What are the reasons? Either it should be proved misbehavior or it should be incapacity. So let me tell you regarding incapacity. If it is incapacity, the incapacity may be physical or mental. But the concerned judge may not be accepting the incapacity. For this reason, the three-member committee may constitute a medical board. Medical board will be constituted to examine the concerned judge clearly. And the concerned judge is expected to cooperate. If the judge is cooperating, he will be verified physically and mentally. Accordingly, report will be submitted to the committee. Right? But otherwise, what happens? What is the guarantee that the concerned judge will be cooperating? Right? If the concerned judge is not cooperating, the same will be mentioned in the report and the report will be submitted to the committee. Right? And the committee will take it for granted that because the concerned judge is not cooperating, whatever the incapacity that is being highlighted, that is correct. He is expected to cooperate. Otherwise, whatever the charges that have been framed, they are considered to be correct. Clear? That is a point number one. Right? So later, the report will be submitted to the so-called the chairman. So in case of proved misbehavior, so generally these are the corruption allegations. In fact, corruption allegations, and investigation is done by three-member committee, and the three-member committee has the right to summon any person before the committee to question, including the judge. Later, the three-member committee will submit the report to the chairman of the Rajya Sabha. Right? Listen, the procedure has been initiated in the Rajya Sabha. That is the reason why the report will be submitted to the chairman of the Rajya Sabha, and the chairman of the Rajya Sabha will present the report before the Rajya Sabha. Now, so this is an opportunity for remaining members of the Rajya Sabha to discuss the report, and the report is has been submitted by three-member committee who are experts. Right. So based on this, all the members of Rajya Sabha will come to know what exactly is the content in the report. During that time, the concerned judge will be asked to appear before the Rajya Sabha, and he will be questioned by the members, and the judge is given the permission to defend himself. Kindly remember, without giving an opportunity for defending himself, you cannot remove anyone. Clear? So this is a law, and the judge will be given enough opportunities and he has every right to defend himself. So to prove that he is an innocent. At the end of the day, what happens is that after the discussion is over, after the questioning is over, Rajya Sabha will go for the voting. In that voting, if it is accepted by special majority, if it is accepted by 2/3 majority, then the resolution is considered to be accepted by the Rajya Sabha. Then the scene will be shifted to the other house, that is Lok Sabha. Clear? I am telling you, Rajya Sabha and Lok Sabha, citing an example that the procedure has been initiated in the Rajya Sabha. Right? So then the scene will be shifted to the Lok Sabha. Lok Sabha will also look at the report. They will have a discussion. Later they will vote. If it is accepted by the Lok Sabha with a special majority, then what happens? Then the joint address will be presented to the President of India, requesting the President to remove the judge. Meaning, the ball is in the court of the President, and the President will remove the concerned judge. Right? The President comes into the picture only after the whole process is over. Please remember one thing. As you all know, judges of Supreme Court and High Court are appointed by the President. Am I clear? Appointed by the President, removed by the President. But after this whole process only, the President can remove. Right? So not before that. Now, another important question is that similarly, if the procedure is initiated in the Lok Sabha, what will happen? Same procedure. 100 members of the Lok Sabha will be giving the notice to the Speaker. Speaker will constitute a 3-member committee. Who are the members? You already know. And this 3-member committee will conduct the investigation. Later, report will be submitted to the Speaker, and the report will be placed before the Lok Sabha, and the Lok Sabha members will discuss it. They will vote it and pass it with a 2/3 majority. Then the scene will be shifted to the Rajya Sabha. Clear? But before voted by the Lok Sabha, the concerned judge will be asked to appear before the Lok Sabha. All right, you are giving him chance to defend himself. Later, scene will be shifted to Rajya Sabha. Again, the same process, passed by 2/3 majority. Then this is presented to the President of India, and the President of India will remove the concerned judge. Over. Hope you are following this one. So what is this procedure? This procedure is mentioned under Judges Inquiry Act of 1968, and that act has been made by the Parliament of India. Am I clear? That's now the point is that so far how many judges of Supreme Court have been removed? How many judges of any High Court have been removed? Answer is 0. So far, no Supreme Court judge, no High Court judge was removed. Please remember this very carefully. It may be a question in any examination. Then your answer should be 0 so far. We don't know what is going to happen to this person. That is the reason why I follow the case carefully. But tomorrow, day after tomorrow, if you are writing any examination, the answer should be none of the judges have been removed so far. Clear? But otherwise, in the year 1993, so there was an allegation against one of the Supreme Court judges by name V. Ramaswamy. So the procedure was initiated in the Lok Sabha, and it was stopped over a period of time. That is the reason why he survived. So again in the year 2012, so there was an allegation against Calcutta High Court Judge Justice Soumitra Sen, and the procedure was initiated in the Rajya Sabha. 3-member committee has been appointed. Report has been submitted. Report was discussed. Justice Soumitra Sen was asked to appear before the Rajya Sabha, and the Rajya Sabha members posed questions to him, and he tried to defend himself. But at the end of the day, members of Rajya Sabha have voted against the judge. Meaning they accepted for his removal, they passed a resolution. And the scene will be shifted to Lok Sabha. The next day it will go to the Lok Sabha. During that time, what happened? And the Lok Sabha was also ready in the year 2012. So to vote against this person, and it was inevitable and obvious that the concerned judge, Justice Soumitra Sen, could have been removed. But on the same day and night, after it was passed by Rajya Sabha, Justice Soumitra Sen has submitted the resignation letter. A judge of the Supreme Court or a High Court submits a resignation letter to the President of India, and the resignation has been submitted by Justice Soumitra Sen. One clause for the judges of High Court and Supreme Court is that the moment they submit the resignation letter, that is considered to be accepted. And once a person has submitted the resignation letter, he relinquished the office. Then how can you remove him? He already submitted the resignation letter. Then how can you remove him? That is the reason why no procedure was initiated in the Lok Sabha the next day. That is the reason why he survived. Clear? So in his footsteps, there was another person by name Justice P.D. Dinakaran. He was a chief judge. He was a chief justice of Karnataka High Court. So, because of the allegations against him, the lawyers and other judges walked out. So, they went for agitation. As long as this person is not transferred from Karnataka High Court, so we are not going to attend the duties. So, by coming under the pressure, so he was transferred to Sikkim High Court. But in Sikkim also, they also protested. Then he was asked to go on leave, and the procedure was initiated against him. Clear? And it was initiated in the Rajya Sabha. Three-member committee was constituted, and they submitted the report. It was supposed to be discussed. It happened just after Justice Swamitra Sen. And Justice Swamitra Sen has shown the way. And P.D. Dhanakaran, before the procedure was initiated in the Rajya Sabha, Justice P.D. Dhanakaran has submitted the resignation letter. He submitted the resignation letter and he rescued himself. Right? And after that, last year, against the same Justice Nagarjuna Reddy, a motion was moved, but some members of the parliament have backed up. That is the reason why. So no step went ahead. Again, it is there in the news because a fresh motion has been moved in the Rajya Sabha, which has been signed by 55 members. And we have to wait and watch what is the step that is going to be taken by the chairman of the Rajya Sabha. Clear? So that is the reason why. So I had to explain this. Hope you understood this very clearly. Right? And kindly remember, judges are Supreme Court judges and High Court judges are appointed by the President of India. Supreme Court judges and High Court judges are removed by the President of India, but after following the whole procedures. That is the reason why removal procedure is really cumbersome. Right? It's very, very difficult to remove a judge of the Supreme Court and High Court. Clear? The difficulty has been deliberately provided only to see that they will have the security of a tenure and they'll be performing their responsibilities without any fear. Right? And if there is a procedure to remove a judge very easily, judges will not be working with lots of integrity. So today we can see lots of integrity in our judiciary because there is no fear and they cannot be removed so easily. Am I clear? So that's about this particular issue. And let's watch what will happen once the sessions will begin, whether it will be accepted and the committee will be constituted. So we need to wait and watch. So I'll stop at this stage and I thank you so much for being with me this evening, and I'll see you tomorrow with the more current affairs. Thank you so much, and I wish you all a very, 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 very good luck. Thank you.